Okay, so welcome everyone to today's webinar on moving your content into the digital world, legal guide for individual artists and arts organizations. My name is Amy Lehman. I'm the Director of Legal Services at Volunteer Lawyers for the Arts. And we are very, very excited to be putting this program on today with the New York Council on the Arts. And the information that's being given today is not direct legal advice. If you have a specific legal question and you'd like legal advice, you can always come to VLA. There's information about where to find us on the materials and on our website at vlany.org. Moving forward from there, we're very, very happy to have Mara Manis, who's the Executive Director of New York Council on the Arts, with us to introduce the speakers. She has extensive experience working with nonprofits, including having been the Executive Director of the Public Theater, which is one of our favorite nonprofit institutions at VLA. Mara, you can take it from here.
Thank you so much, Amy. And thank you all for joining us today for the third installment of our NYSCA Presents webinar series. As always, and especially during this time, we are grateful for the governor's steadfast leadership and his recognition of the critical role that arts play in the health and vitality of our state. Like many of you, we are still processing the continued injustices faced by the Black community. But we know that all of your work as artists remain vital. Throughout history, artists have created out of our collective pain, and artists will contribute to our healing as we move together to strengthen our communities, our state, and our country. In our state, the arts sector contributed $120 billion to our economy, and arts play a critical role in our workforce, tourism, and hospitality sectors. The reopening process is underway, and we know that our sector will be vital to our recovery. The NYSCA team is dedicated to supporting you in every way that we can as a resource during this time of transition and beyond. The entire team has been so inspired by the creativity in reimagining your programs, both for the digital audience as well as the social distance ones, that your work has inspired us to create our NYS online channel on our website. Today, we are pleased to present in partnership with VLA important legal information about working in this digital medium that many, if not all of us, have had to pivot to. We are grateful to VLA for this free presentation, which will be posted on our website and their website very shortly. You can also find our previous webinars on fundraising myths and digital communications on our site, and we're really delighted that our 2 webinars so far have garnered almost 2,000 views. As always, please remember to submit your questions in the Q&A feature throughout today's presentation, and the team will do their best to respond. I'm excited to introduce our speakers. Joining us from Simpson, Thacher, and Bartlett, Lori Lesser, partner in Simpson's litigation department and head of the intellectual property transaction practice, as well as co-head of the privacy practice. Chris Sprigman, counsel in the intellectual property group and litigation department, as well as professor at NYU Law School. And Maura Whalen, counsel at Simpson Thacher's exempt organizations practice. It's an honor to welcome Chris, Lori, and Maura to our screens. And now over to you, Chris.
Okay, everyone, thanks. My name is Chris Sprigman. I'm a counsel at Simpson Thacher and a professor at NYU. I teach copyright law, trademark law, antitrust, a little bit of comparative constitutional law. I'm going to talk with you guys today about the IP decisions involved in moving your programming online. It's actually a fairly complex area of the law. I'm going to try to cover it at somewhat of a 30,000-foot level, try to be accurate while being quick. This part of the law wasn't necessarily built for small nonprofits and individual creators. It was built for larger companies that typically have large fleets of lawyers available to them. So some of the complexity is unavoidable. But let me just talk a bit about copyright law, which is going to be the major topic for my talk. And let's start at the beginning. What does it cover? So broadly, copyright law covers artistic and literary works. It grants rights to copyright owners in those works, typically to authors or the people to whom authors assign rights, like publishers. And copyright covers literary works like books or poems, audiovisual works, so motion pictures, for example, or audiovisual presentations put online, dramatic works, plays, choreographic works, dances, pictorial, sculptural, and graphic works, architectural works, although probably not directly relevant to many of you here. And then there are two types of works that often fly in formation: musical works, that is musical compositions, so think of that as sheet music, and sound recordings, so the recorded performances of musical works. Those get separate copyrights, and as we're going to see, that's actually going to be significant for a number of you who are looking to move or provide some programming online. So what are the exclusive rights of the copyright owner? So the law, the Copyright Act, grants to the copyright owner a set of exclusive rights that include the exclusive right to make copies, to reproduce the work, the exclusive right to create derivative works, so new versions of a work, the exclusive right to distribute copies of the work, the exclusive right to make public performances or public displays of a copyrighted work, and again, important to a number of you who are going to be moving programming online, the exclusive right to engage in public performance of sound recordings by means of a digital audio transmission. Public performance of sound recordings by means of a digital audio transmission. So what does that mean? Well, we're going to get into some scenarios where I think that can become a little clearer. So let's just put a pin in that and come back to it. Okay, slide doesn't want to move. Let's try it again. Here we go. So let's talk about different types of licenses you may need if you're going to put programming online. And I want to start with photographs. And why do I want to start with photographs? Because a lot of you are going to be putting photographs online or using photographs online. There is no collective licensing or statutory licensing of photographs. Licenses to reproduce, to publicly display photographs need to be obtained from the photograph's copyright owner or the agent of that copyright owner. So many of you might be familiar with companies like Shutterstock, for example, or Getty Images. These are typically either owners or agents on behalf of other photographers with whom they contract, and you can get licenses through them, commercial licenses. But there's another option available to you, and it might actually be for nonprofits and individual creators, might actually be a very productive one, and that is Creative Commons. If you go to creativecommons.org, and I've got some screenshots here from Creative Commons just to give you a sense of what this is about, you'll find available to you a search engine that allows you to browse through millions of photographs, many millions of photographs that are licensed according to one form or another of a Creative Commons license. So what do Creative Commons licenses do? They allow you to use, here photographs, but more than photographs. Music can be licensed according to Creative Commons. Books can be licensed according to Creative Commons licenses. They allow you to use these copyrighted works without a fee and with certain permissions. So for example, I looked for photographs of dancers. You see at the bottom of the screen there, you'll see a search box, and you'll see I typed dancer into that search box. And this pulled up a whole bunch of photographs, one of which I really liked is titled Ballet Stage Lighting. It shows who the author of that photograph is, and it shows the license. It's licensed, if you look to the right, you see the photograph of dancers, and you see it's licensed under what's called a CC BY license. So that license allows you to use that photograph. It allows you to use it for commercial or non-commercial purposes. It allows you to distribute that photograph. It allows you to make derivative works based on that photograph. You are required to credit the author when you do so, and there's information in that license about how to do that. But other than that requirement, you are free to use that photograph. Creative Commons is a repository for a lot of works that are available to you that you might be able to use. Let me give you some other sources of non-copyrighted content, or if it's copyrighted content, it's permissively licensed. One is federal government works. Works of the federal government can't actually be copyrighted. So various federal government websites make works available. Also museum collections. Various museums make works available on pretty permissive terms. So I've given a really nice example here. I think it's a photograph of the ruby slippers that we used in The Wizard of Oz. This is a photograph that is put online in quite high resolution by the National Museum of American History. That's part of the Smithsonian Institution. And if you look at the bottom, it's licensed according to a quite permissive license. It's a Creative Commons license. So you can read the terms of that license. It allows you to use that content under certain conditions, but they're quite permissive without charge. So other types of licenses you may need. So if you look down the slide here, we've discussed photographs, but let's discuss some other types of works. What about literary and dramatic works, like books, for example, or plays or poems? If you want to reproduce these and distribute copies of them, or if you want, for example, to publicly perform them, which you would be doing if you perform them and release that performance online, you need a license to those works. That's a license that can be obtained only from the owner or the owner's agent. Same with choreographic works. If you're going to, for example, publicly perform a dance which can be copyrighted and often is as a choreographic work, you need a license from the owner of the choreographic work or the owner's agent. Now, this raises some issues. So how do I find this person, right? And often, right, that's a bit of a puzzle. So ownership information about dances or about musical works or about literary and dramatic works is often available, but sometimes when it's not available, this creates a bit of a barrier. If people have questions about that, we can talk about that a little further. Okay, so what about music? So music has a very, very special licensing structure. There are licenses available that are made available by law, and then there are some licenses that you have to negotiate individually. So let me talk about the various licenses. Okay, first for sound recordings. So if you're going to publicly perform a sound recording by means of a digital audio transmission, remember I mentioned that a few minutes ago. So for example, if you're going to publicly perform a sound recording by playing it in a webinar, and that webinar is going to be made available to the public, you need a license for that. There is a statutory license for webcasting, non-interactive webcasting, that's made available through an entity called Sound Exchange, and you see the link I have up there. So you can visit that link and you can find out more about statutory licenses for the sound recordings that you may wish to use in your online programming. Musical compositions have a different licensing regime. There's a couple of different types of licenses that are going to be relevant to you. One is a mechanical license. So what is that? That is a license to make an actual copy of a musical composition. In other words, to make a sound recording of that musical composition. That too is a license that is made available through the statute, through the Copyright Act. And there's an agent named Harry Fox that it's not a person, it's a company that has traditionally provided these types of licenses. I've provided a link to you, harryfox.com. This entire licensing regime is in the middle of some change. Last year, a statute was passed, the Music Modernization Act, that hopefully will make this form of licensing a little bit easier and more convenient. But for now, Harry Fox is at least the best known agent to obtain these compulsory mechanical licenses. Now, in addition to a compulsory mechanical license, you might need, if you're distributing and making public performances of musical compositions online, so you have an orchestra, for example, that's performing a copyrighted musical composition, you will need a public performance license. These are available through some private organizations that are collectively known as performance rights organizations. These might be familiar to you. ASCAP and BMI are two that are quite long-standing and famous. There's also CSAC and GMR. These are entities that license public performance rights for musical compositions. So if you have a program that you're planning where a musical composition that's copyrighted is going to be publicly performed, that is the agent that you would use to get licenses for that performance. Let me mention finally sync licenses. This is a mystery to a lot of people. What is a sync license? You hear the term sometimes. A sync license stands for synchronization license. It's a license that you need if you synchronize music with video content. And often that happens in performances that might be made available online. Sync licenses are not licenses that are made available via some kind of statutory or compulsory provision. These are licenses that have to be negotiated individually with the owner or the owner's agent. Okay, let me talk about a few scenarios that I think will help put some of this information into context and hopefully help explain it a bit better. So let's start simple. Scenario number one. An organization wants to do an online presentation of a musical performance. You want to have a bunch of musicians sitting in a room. They're going to play a song. The song is a musical composition. That musical composition is copyrighted. It's a musical work. What do you need? Well, first you need a mechanical license because you're recording a performance of that copyrighted musical composition. And to make that mechanical reproduction of the composition, you need a license, right? So Harry Fox is who you call. You also need a public performance license because you are going to be publicly performing that musical composition, that copyrighted musical composition, when you make it available online and the public accesses it. And so ASCAP, BMI, CSAC, those are the performance rights organizations through which you can source a public performance license. Okay, relatively simple. It gets a little bit more complicated, and then it gets a lot more complicated. Okay, so scenario number 2, online presentation of a musical performance accompanied by images. Okay, so again, we're making a recorded performance of a musical work, which means we need a mechanical license. Then we need a public performance license for the musical composition. And then we also need a sync license because we are synchronizing the musical performance with the images. So we need to license the musical performance for the synchronization. That license is available only for the owner, through the owner or the owner's agent. As well, you have to think about the images, right? So the images are pictorial, graphic, or sculptural works. They're pictorial works. And pictorial works need to be licensed from their owner or the owner's agent. So if we have a bunch of images that aren't sourced from a place like Creative Commons or a place like a museum that has very permissive licensing terms, if they're sourced from an author or an author's agent, so like Shutterstock or Getty Images, we're going to need to get a sync license as well as a license, a public display license for those works. Okay, scenario number 3. This is a complicated one. We want to present online a dance performance. So here we have a whole bunch of works interacting. We have a choreographic work. It's possible that we might have a copyrighted dance. We have an audiovisual work, right? We're creating an audiovisual work. We might include copyrighted musical works in our performance, right? We might actually be performing and publicly performing a copyrighted musical work. And we might actually play also a sound recording. We might, instead of recording our own version of that musical work, we might play someone else's version of that musical work. We need a license for all those things. If the choreographic work is copyrighted, we need to get a license from the owner or the owner's agent. If the audiovisual work we're creating is going to be copyrighted, if we want to claim a copyright in it, the copyright arises the moment that audiovisual work is fixed, but we might wish to register that with the Copyright Office. That gives notice of our copyright claim. It also allows us to have some enhanced remedies in the case someone infringes our work and we don't like that. The same licenses for musical works and sound recordings that we talked about earlier we'll have to obtain in this scenario. Let me move on. Just a few additional things I want to say, and then I'm going to stop and turn it over to Lori Lesser to talk about privacy issues. We have a few additional concerns here, just various concerns that nonprofits and individual artists who are thinking about moving programming online should keep in mind. So domain names. Many of you probably already control domain names. For those of you who control domain names or are thinking of registering domain names, be careful to register the domain names that you want to control and the principal variants of those domain names if they're available. This is to prevent something called cyber squatting, which is other people coming in, registering domain names that you want to control for the purpose of essentially squeezing money out of you to turn over the property of the domain name. There's a whole cyber squatting enforcement regime that I can describe if anyone's really curious, but it's a whole bunch of like time and money and bother to evict cyber squatters. So an ounce of prevention is worth more than a pound of cure here. In terms of user-generated content, if any of you are thinking of allowing users to post content to a site that you control, that exposes you potentially to copyright liability. The Copyright Act contains within it a safe harbor under what people refer to as the Digital Millennium Copyright Act. There's a safe harbor under Section 512 of that act if you do a few things to qualify for it. And one of the things you need to do is to have and to enforce a repeat infringer policy. So if people more than one time post infringing content to your user-generated content site, you should be prepared to bounce them and to take steps to make sure they stay bounced. You also should set yourself up to respond expeditiously to takedown notices. If a copyright owner writes you a letter or sends you a takedown notice saying, someone posted copyrighted content of mine, you should prepare yourself to respond expeditiously and take down that allegedly infringing content. Now, the system, which I can describe in a bit more detail if people are interested during questions, the system allows people to counter notify. That is to say, no, I'm not violating copyright. I have a license, or it's fair use, or I actually own this content. You need to prepare yourself to respond to those counter notifications as well. One last thing on DMCA, it's very, very simple, and people sometimes don't do it, and it gets them in trouble. Name an agent to a DMCA agent to receive these takedown notices, and register the name of that agent and their contact information with the US Copyright Office, and keep that registration current. Because if you run a user-generated content site and infringing content is posted by a user, you want people who own that content to be able to know who to write to, who to call, who to email. That's important. So pretty simple, but something that you should do. Finally, terms of use for your website. Just in general, make sure your website terms of use clearly explain what's permitted and what isn't. What's permitted is, if it's a user-generated content site, posting content that is not violating copyright, posting copyright violating content not permitted, and in general, terms of use should be kept up to date and as clear as possible. And that brings us to the broader issue of privacy law, which Lori is going to talk about. Thanks, everyone.
So Chris, you're not off the hook yet. We're going to be asking you some questions now for a few minutes. We'll start going through a few of the questions. We have, of course, so many attendees and we have a lot of questions, but we will see what we can do to get some of these answered. And just so everybody knows that also the PowerPoint and some additional materials will be available on our website once this CLE is posted on our website in a few days. So let's see. I have a question about teaching artists. So here's the question: how are arts organizations approaching the conversation of intellectual property with their teaching artists? So as an arts organization, do they have the rights in the recorded classes and workshops? But then how are the teaching artists being protected?
So that's a great, great question. And the answer is a little bit complicated. Copyright law has something called the work made for hire doctrine. So typically, the author of a copyrighted work is also the initial copyright owner. But under the work made for hire doctrine, if the person who actually creates the copyrighted content is the employee of the sponsoring organization and is acting within the scope of his or her employment, then the copyright law considers the sponsoring organization or person to be the author and the initial copyright owner, not the person who actually created the content. That's a little weird, it's a little counterintuitive, but that's how copyright law has worked for quite some time. So whether, in fact, the work made for hire doctrine applies depends in part on whether the person creating the content is an employee or an independent contractor. If it's an employee, then the doctrine will apply relatively broadly. If the person creating the content is an independent contractor, the doctrine applies much more narrowly. It only applies to certain specified classes of works, which you can find in Section 101 of the Copyright Act defined. And also, it only applies if there's a written agreement between the parties that denotes the work as a work made for hire. So if the creator is an independent contractor, absent those steps, and most notably a written agreement, the work is, at least initially, belongs to the person who creates it, and the copyright does as well. Now note that even if the work is not made for a work made for hire, often sponsoring organizations will say that any copyright that you have in the work will transfer to us, and part of what we pay you is for that transfer of that copyright ownership. But again, that's a contractual agreement. That doesn't really have to, that's not mandated in the law. Copyrights can be transferred, and that's really a contract issue then.
Right. Okay, great. Thank you. So Mara, I think you had a question you wanted to address. Or
sure. I'm gonna share one of the questions from the audience, but I also just wanted to ask Chris a clarifying question about the DMC agent that you're recommending register. So who should, when organizations are thinking about who to appoint to such a role, how does one make that decision?
Well, one simple thing to say is it's someone who pays attention and who responds to correspondence quickly. It's both legally valuable to respond quickly and also just courteous to people who are writing to tell you that there may be a copyright infringement going on your website, that response happens quickly. So someone who has some training in what takedown notices mean and what the company or what the nonprofit or what the company's responsibility is under the law to respond to those notices, that's the right person to name as a DMCA agent. And you should keep that information up to date. The Copyright Office requires you periodically to certify that that information is up to date.
Okay, so it sounds like that a number of staff people could be trained for that with no legal background whatsoever, right?
Doesn't necessarily require a legal background, but someone who's like on the ball.
Got it. Okay. Okay. So here's a question from a small music organization about musical compositions. We play only older music that is generally in the public domain. However, some of our performances use contemporary editions of older music, and the editions are under copyright. For a concert reference recording, do we need to seek a license in such a case?
So that is a complicated question. Let me just give you an example of when you would need to seek a license. So there are songs in the public domain, songs that are old, and any copyright that existed on those songs has run out. But sometimes these songs are arranged anew, right? There's a rearrangement of a traditional song, and that new arrangement is a new work. The new portions of that work are protected by copyright, and so the song might be very old, but the arrangement might be relatively new. And if you publicly perform or record that particular arrangement of the traditional song, you need a license.
That's great. Amy?
Yeah, so here's another question, and actually we have a few questions that sort of go to the general area of fair use, which I'll get to in a minute. But before that, I have this one, which is someone saying, if you have permission of the composer and if necessary from their publisher, so they have a license or they've been granted permission, do they still have to get a mechanical license from Harry Fox?
I'm sorry, so could you repeat that question? I'm not sure.
So if they already have permission from the composer, for example, whether it's granted or licensed, do they still need to get a mechanical license from Harry Fox?
No, if the owner of the Harry Fox is an agent, right? They act on behalf of copyright owners. If the owner itself has not ceded to some agent the power to give authority, but the owner still has the power to give authority, and they get authority from the owner, job done. That's why I said owner or agent. It depends on the circumstances, but if you get authority from the owner and the owner hasn't in fact given up the ability to give that authority, then you're covered.
So I have to say, we have so many questions that I'm sorry we're not going to be able to get to all of them, but we'll do our best. So
I see one from a museum. Should I take that? Okay.
Sure.
And
then
so I'd like some clarification on use of images, on usage of image of artworks from museum collections. As I understand it, for museums that own modern or contemporary works, for which the artist or estate is present / active, the museum cannot in good faith grant usage of the image. The artist / estate must grant that permission. Is this the case?
So if you're talking about contemporary art, the art is copyrighted. So let's talk about a painting, a contemporary painting, something that was painted in the last 20 years. So that is a copyrighted artistic work. And to make reproductions of that work in whatever medium, including photographs, is within the exclusive right of the copyright owner. So let's imagine that the artist or the artist representatives still owns the copyright in that painting. They haven't sold or transferred that copyright. So the museum does not have a right to make copies of the painting. The owner of the copyright has the right to authorize the making of copies of the painting, even photographic images of the painting. And so legally, the museum needs permission from the owner of the copyright to actually distribute images of the artwork. Now, I'll be careful about this because if, for example, an owner of an artwork puts the artwork in a museum to display it, lends it to the museum to display it. Or if the owner of an artwork, for example, gives the artwork to a gallery for the purpose of selling it. Typically, we would imagine that there's an implied license for the museum to post an image saying, hey, we have this painting, come see it. Or for the gallery to post an image saying, hey, we have this painting for sale, come buy it, right? That is very different than if the museum prints up 10,000 images and sells them in the gift shop, or if the gallery actually sells images of the painting, makes 10,000 copies and sells them. That's different. The thing that I mentioned is likely to be either an implied license or a fair use.
Okay, thanks.
Okay, so on that question of fair use, and I think this has to be the last question for this segment. So someone is asking, what if they are streaming a musical performance online and not charging admission, so it's not for commercial purposes, or if it's for educational purposes? Do they then still need to get a license to use the material?
So I give a lot of advice on fair use and have over the years. And let me just say, my first piece of advice on fair use is it's very difficult to give fair use advice wholesale. It has to be given retail. And in particular, it has to be given with precise attention to facts in a particular case. Let me just give you a couple of guidelines. Just because a use is non-commercial doesn't mean it's fair. Just because a use is commercial doesn't mean it's not fair. The non-commercial nature or the commercial nature of a use are relevant, certainly, to the fair use analysis. The fair use analysis asks us to look at least 4 things, but we can look at more things if they're relevant. The 4 things that we have to look at a minimum are the nature of the use. So is the use commercial or non-commercial? Is it for the public benefit or is it for private gain? The nature of the work being used. So is it a kind of work like a photograph or like a poem that's close to the heart of copyright protection? Or is it the kind of work that's like heavily factual or heavily functional, like software that's a little bit closer to the periphery of what copyright protects? How much of the work is used, right? Is it all? Is it some portion? What portion? Is it the heart? Is it the hook of the work? Or is it some other part? Is the use transformative, right? Is it a use that is dedicated toward creating something new, or is it just a mimetic use? And, often quite importantly, what's the effect on the market for the work? Is it the kind of use that's likely to have a significant effect on the market for the work or not? These are all factors that courts direct us to consider. We can consider lots of other things if they're relevant in a particular case, but that's basically what I can tell you. It's a standard, it's not a test, and it requires a fair amount of attention to the specifics.
Okay, thank you. All right, so we're going to move on now to Lori, and Chris, you can share your screen again.
Will do.
With Lori's slides.
I'm going to get there. Hang on one second. Here we are.
All right, thanks everyone.
There you are.
Can you see me? Or
We can see you, Lori, and we can hear you. So
great. So
go
I have the daunting task of presenting the world of privacy in 15 minutes or less. Everyone wants to regulate privacy these days, and everyone does. You have 50 state legislatures who want to regulate it. You have 50 state attorney generals. You have the US federal government, and you have foreign governments. And it gets a lot of press. You know that California had a new privacy law that took effect in January. For years, we heard about the European Union, which has the general data privacy regulation, so protection regulation. So we need to make sense of it in a way that has news you can use in 15 minutes. The fortunate thing is there is a lot of overlap, and there are some principles that you can distill. And if you follow these principles, then you will be in compliance with the privacy laws, whatever they are. First of all, what do privacy laws protect? They protect personal data. What is personal data? Personal data is any piece of information that helps, oh, Chris, go back to privacy. I'm seeing cybersecurity on my screen. Go back one more. Thank you. Personal data is any piece of information that helps you decide who you are communicating with, whether it is a person or whether it is a computer. Any piece of information will do. It could be a name, an address, a driver's license, a social security number. It could be something with your computer. It could be your browser history. What are you doing on third-party sites? So basically, any kind of information that you interact with on your website or your mobile app probably counts as personal data. And if you have it, then you have to protect it. And sorry, I'm having a little technical difficulty. Amy, tell me, are you seeing the right slide or are you seeing the cover slide?
Chris, can you stay there? That's the right slide, I'm thinking, yes? The privacy slide, or do you need to move on?
No, that's fine. That's the slide for now.
Okay.
So basically, all of us collect personal data. If you anonymize it, then most of the privacy laws, or almost all of them, do not apply. But if you keep it so it's separate and people can figure out what person the data belongs to, then you have to protect it. So the question is, what do you have to do? First, if you have a mobile app or if you have a website, you need to have a privacy policy. All of us interact with websites and mobile apps, and all of us have seen these privacy policies. There are things that you click through, and frankly, unless you're a lawyer in the field, you probably don't read them very thoroughly. But we all need to have them. I've posted the VLA Terms of Use and Privacy Policy so you can review it, and 2 websites that get very good reviews for helping you generate your own. So if you go speak to a pro bono lawyer or someone at VLA, you actually have a template for a privacy policy that you could start with. So when you have a privacy policy, basically, what needs to be in it? First, you need to provide a contact person in case someone has a privacy complaint, they know who to go to. And this is generally privacy@yourname.com. As Chris and Mara were saying, privacy@yourname.com should forward to someone in your organization. Does not have to be a lawyer, but someone responsible who has training, who knows how to respond when they receive complaints. Second of all, you need to tell the world what you will do and not do with their personal information. How are you going to use it? Are you going to use it internally to improve their experience on the website? Are you going to use it to provide better programming that they might be interested in? Who are you going to disclose it to? Will you only keep it in your organization? Will you disclose it to your vendors who provide you services? Do you have joint partnerships or marketing arrangements with other parties who may send them solicitations for funds or may send them other programming materials? People should know how you will use and how you will disclose their information. And there are a few categories that you will see privacy policies generally cover. Do you put cookies on people? Do you drop cookies so people know what sites have been visited? Do you use Google Analytics so that you can get a better sense of who is visiting your site? And what do you do with that data? What about if your users have set their privacy settings because they don't want you following them offline to what they are doing on third-party websites? How does your website technically interact with any such signals? These are the things you should tell people what you are doing. Also, you can tell people what you will never do. If you commit that you will never sell their personal information and you feel people would be comfortable hearing that, you can put that in your privacy also. The important thing is, once you put it in, what you do and don't do, you must practice what you preach. One of the fastest ways to get in trouble with the regulators is to promise one thing in privacy and do another. So make sure that you are always familiar with the most recent copy of your privacy policy, what you say you will do, and that you are abiding by it in practice. That's the general policy. There are some specific situations you need to think about. If your website is targeted to people under 13 years old, you will need parental consent to collect information from children of that age. Now, obviously, anyone can visit a website, and someone under 13 can visit a museum website. That doesn't mean you qualify as targeting them. But I imagine we have people on this webinar today who do youth-oriented theater projects. If you run puppet shows, if you are offering arts classes to children, there is an argument that you are targeting children under 13, and you will need parental consent and need to comply with the laws in that regard. It's unclear who handles their own credit card information. If you take donations or sell tickets online, you may have an outside vendor who does that. But if you take credit card information, you have special standards you need to comply with to make sure you keep that safe. So depending on specific things you are doing, you need to cover that in your policy. And a good way to decide what to do is think about other organizations like you, perhaps much bigger and more well-funded organizations who have been online with a big presence for years, and look at their privacy policies and see which topics they find relevant, and they will likely be the same topics that you need to cover. I'm going to skip to sensitive data. That is an interesting point now. Now you have organizations, all kinds, who are collecting health-related information, such as people's health and travel plans in order to keep their workforce safe from coronavirus. You may be collecting information like that from your subscribers or future audience members. Special rules apply to collection of sensitive data such as healthcare information, and we've given you a memo to review in that regard. One interesting point is you don't have to be concerned with personal data you don't have. So don't collect data you don't necessarily need. In the past, it was probably very tempting anytime you sent out a survey or a questionnaire or someone filled out a form to buy tickets, you might as well collect all sorts of information about people because you might want to use it someday. But once you have that information, you have to protect it. And so maybe you want to think about collecting only what you need so you don't have the worry of protecting what you don't need. And finally, if you get an email to that address, privacy@yourname.com, you need to respond, just as Chris covered with the MCA complaints. There are laws that say you have to respond, and they tell you what you need to do and how much time you have to do it. So if you receive a complaint, that would be an excellent time to contact your attorney to make sure you do it correctly. If you can move into my cybersecurity slide, please. So the same patchwork of many, many regulators also governs cybersecurity. You have the states, you have the US federal government, and you have foreign laws that cover cybersecurity breaches. So what do you need to think about? Let's just say you have a privacy policy and you have done everything right, and you have not breached anything you told people you would do, but you get hacked and information that you were entrusted with is compromised. Are you liable? What do you need to do to make sure you have not violated the law? So I'm going to give you some general principles that apply across the board of the patchwork of laws that govern this field. No one expects you to have perfect cybersecurity. It does not exist. There would be no news stories in the papers if we had perfect cybersecurity. Even the best companies get hacked, and no one expects that you can guard the world against every possible risk. You do have to have quote unquote reasonable data security systems. Reasonable is not defined in the various statutes. They're not going to give you a specific vendor. They're not going to tell you that your password needs to be 22 digits and not 23 digits, because you could always do slightly better if you had an infinite amount of money, and because the world changes. So reasonable will be applied in context. Everyone knows that the people on this webinar do not have the budgets of the big tech companies, but you should think about having the best data security system that is reasonably available, given your resources and given the nature of the information you're collecting. Not everyone's information collected will be as sensitive or potentially harmful as everyone else's, and you should be reasonable in context. What else do you need to do? You need to have a plan. If we all remember when we were kids, we had the home safety drill, and you were supposed to have all the important phone numbers to call in an emergency, and you were supposed to practice your fire drill and be ready to go so you didn't panic if an emergency happened. The same is true for cybersecurity. After a breach is not the time that you want to assemble the phone numbers and the plan and figure out what it is you need to be doing, who needs to know, and when they need to know it. So put your cybersecurity plan together and make sure all the necessary people know how to find it, because also hacks can occur on the weekends or on a very late night, and you need to be ready to go at a moment's notice. Also, cybersecurity does not exist just at one moment in time. Your vendor sets up a system, and that's not the end of it. You need to test it. If you have vulnerabilities, you need to fix it. If your vendors send you patches, you need to install them. You have to make sure your systems stay up to date. And you also need to train your staff. We all hear from friends and also in the press about ingenious methods used by bad actors to get employees to give them a password or to send them money. And you need to make sure that your staff is trained so they can spot these things, which are often quite successful, and the bad actors are getting better and better at them. Your privacy policy will briefly discuss what you say about cybersecurity, and again, anything you say in your privacy policy, you need to comply with. You also need to have a holistic view of cybersecurity. It's not just your website and your mobile app, it's everything in your organization. If we ever get to go back to our offices, you need to think about your physical security, whether there are files you need to discard, whether you're holding on to information in a warehouse that you no longer need, whether you need to shred documents, whether you need, excuse me, I don't know who's doing that. Whether you need to lock your offices, whether you need to lock your office, whether you need to limit the risk of an inside job and make things password protected so people cannot find them. Also, given that many of us are not in our offices, you have the entire work from home situation, and everyone is porting into your system through a variety of phones, iPads, and various devices, and you need to think through the security concerns that go with such interactivity. Finally, you need to think about your vendors. You may have outsourced the hosting of your employee payroll information, your donor solicitation information, all sorts of things to outside vendors. What if one of them has a hack? You can't control it, and maybe your information is compromised. Again, you do not have to be perfect, but you are responsible for reasonable selection of your vendors and reasonably monitoring them. So do not choose one college student in a garage because it's a friend of someone involved with the organization. You need to select the most reputable vendors that you can afford on your budget, and you need to keep an eye on them that they're doing your job. And by the way, while you're monitoring them, make sure you read their contract and your insurance policy. Cybersecurity is really the hot potato. Nobody wants to pay for the risk because everyone knows the hackers could strike anyone. So vendors very much want to disclaim liability or put a very tight cap on it. So you need to think about whether you actually are protected by your vendor and how much. Also on insurance policies, cybersecurity insurance is very expensive, and almost no one on this call probably has a separate cybersecurity policy. If you do, that's terrific. If not, you should check your general insurance policies and see what kind of coverage you have, deductibles, exclusions, so you're not surprised on how well you are protected. And finally, in the unfortunate event that you are breached, you are supposed to notify the people whose information may have been compromised, unless it's anonymous, or in many states, unless it's encrypted. Also, in certain cases, you have to tell the state attorney general in various states. So if you are breached, you definitely want to contact your lawyer to make sure you respond correctly to the right people and in the right amount of time. So Amy, that's my part of the presentation if anyone has any questions.
So, Lori, here's a question. Does an independent freelance musician need a privacy policy for their website?
So the question is need. As you know, as a legal matter, absolutely law on the books, yes, because someone could visit your website from California, and California has a statute that you need a privacy policy if you interact with a California resident. If you're a New York local musician, you're not trying to contact anyone from California, but technically you have. If you haven't had one up until today, should you lie awake nights thinking that there's going to be a terrible consequence? No. I think people understand you're independent, you're acting in good faith, you're in New York, but technically speaking, every website should have a privacy policy, and as a lawyer, I have to say yes.
Okay, thank you. So here's an interesting one. Is it legal to copy another company's privacy policy if you don't have one yourself?
That's also a Chris question, so Chris can correct me if he has anything to say. Most privacy policies, if you read them, sound 90% the same. If you are reciting a law, nobody owns a law. And most of them are so basic and so boilerplate that this is not the stuff of copyright litigation. That being said, I wouldn't just photocopy it because no two companies' situations are exactly the same. And so you're going to have slight things that are different. And I think also you want to say it in your own voice, like a very expensive, well-funded website, versus a very young and hip and low-funded website are speaking to different audiences, and you're responsible for communicating it in language that your users can understand. So I think you should get familiar with other people's sites to make sure that you've covered all the topics. A good chunk of it is going to look alike, but I wouldn't just cut and paste and not do anything else.
Right.
Yeah, I think Lori said exactly what I would say. So thank you.
Great, thank you. So here's another interesting question. How does privacy and security apply to teaching online? Because we have all these people who are now posting their classes online that they didn't used to.
Well, I think there's two things. There's one, what kind of information are you collecting? So it's the same things we all deal with. If you're collecting the names of students and you're collecting personal information about who's watching you, I think that's no different than anybody collecting that information because they're going to come and be in your audience, that they're going to make a donation. I think in terms of the content that the teacher is conveying, it's the intellectual property clearance that might need to be done if the teacher is using third-party videos. And I mean, I guess it's whether the teacher has somehow invaded someone's privacy in the content that they are conveying, which is sort of slightly different. That's a sort of slightly different area of privacy law than we're talking about collecting information from people. So I'm not sure that really changes the risk profile.
Okay. I have a interesting question over here. It says, my son has games on Roblox. Does he need a privacy policy since he's using their site to host his games? They pay him a percentage of sales.
Is it the Sun's website, or the Sun gave them a game to put on their own website?
It sounds like
He's using their site to host his games.
Okay, so I mean, I'd have to know the technical details, but if he is not touching the personal information, if he is not collecting it, if they are not giving it to him, and it's possible they send him summary information or they forward him information, if you don't touch the information, then you don't have to protect it.
Okay. Lori, this is such a fascinating area, and I'm just wondering, we support so many really small organizations with budgets of operating budgets of under like $500,000. And so they don't have big staffs. And where does one start to develop, privacy policies? What would you say you need to put in place? Absolutely, like numbers 1, 2, and 3.
So I would say numbers 1, 2, 3. First of all, there's the links that we posted that kind of help you do it yourself. And again, when it's all done, you should have a lawyer review it. But the do it yourself will ask you questions on what kind of data you're collecting and what you're doing with it. I think that will help you put it together. I think you should look on the web for organizations that are doing what you do. I mean, maybe they're doing it and making more money out of it, but if they're doing the same types of things, you think they're collecting the same kinds of data, I think you can learn a lot by looking at what other people have done and larger organizations. But mainly, you need to find a way for people to complain and to get to you quickly and efficiently if they want to complain. And you need to just tell them, what you're going to do with their data. And that means both how you're going to use it and how you're going to disclose it. So if they visit your website, they're warned and they know what you're doing on your site. That is basically what you need to do.
And are you posting that policy on your site?
So if you look at most sites, if you go to, and again, mostly lawyers bother to read this. I think the general public does not. But if you scroll down to the bottom of the homepage, the standard place to put it is where they have all the buttons. And there's the contact us button, about us, who we are, donate, like all the buttons are there. There's usually a button that says term of use, and there's a button that says privacy policy. And if you click on the privacy policy, that's where it is. You don't have to take 50% of your homepage and destroy its beauty putting your privacy policy there. It's usually in a tab that's on the homepage. And some people have tabs that are specifically related to California, given the new California statute. But you don't necessarily have to have that if you have the right information in your general privacy policy. On mobile apps, it's usually something you're clicking through and saying, I agree, and that if you're not a lawyer, you're probably not reading. But it is there, and if you click on it, you would read it and it would look about the same.
Great, thank you. Amy?
Okay, so I have one more and then I think we'll move on to the next section, but this last one actually made me giggle. So what if you're hired to present an online program? Lori, can the producing organization record the program for future streaming or other use? Does the individual have separate rights for those future uses?
So that is a good question. So we have given VLA permission to post this on its website. So that's sort of a right of publicity, which is a slightly different type of right than the privacy and cybersecurity we are discussing. I think if you have any sort of written agreement where you are the quote unquote talent that are appearing in a video, then you should put in any sort of agreement. And again, this can be in an email. You don't have to document it in some extremely formal way, what you do and don't think the organization can do with that video. And you should work it out before you consent to doing the video. The laws on the books about privacy and publicity usually are about a commercial use of your image. So if I made this video for VLA and without my consent, you went and sold it as a DVD series, then I might have a complaint depending on how you did it. Or the classic example is if you take my photo and you put it on a cereal box and you sell the cereal and you don't pay me, then that's a right of publicity claim. But for something that's an educational purpose, for something that's done to promote important public discussion on an important political idea, using videos of people generally does not violate a law. So it's a question of what you work out in a contract with the people in the video. So I would say to anybody on this call, if you're doing something and you don't want it further distributed, I think you need to work that out ahead of time in writing and make sure that the organization promises to respect your privacy.
Amy, I have one more question.
Yeah.
Can I get it in? Because
yeah.
I think it applies to probably most every organization that we support and beyond. So what are some basic challenges in uses for emails you may have collected from donors or registrants to online events?
I'm sorry, recent challenges?
So basic challenges. So in other words, what's your liability in using the emails that that an organization may have collected from donors or registrants for online events?
Right. So two things. First of all, what have you told the donors and registrants you would do with the information? That's either on your privacy policy, or if you sell through Ticketmaster, it's their privacy policy. But in the way that they interacted with you to buy the ticket, at some point there was a privacy policy that governed. And you may use the email addresses in any way that does not violate that policy. But if you told them that they would not be given to any other organization to market to you, and they get some other emails from a totally independent organization that says, oh, I hear you like music, you know, here's a ticket to this, they may not be happy with you, and that would violate the privacy policy. So it has to be consistent. And second of all, that's personal data. The email address is personal data, and now that you've got it, you have to have a reasonable security program so you don't get hacked, because if you get hacked and you had poor security, then that would be a different security violation.
Excellent point. Thank you.
Okay. And now, Maura Whalen, you can share your screen.
Everyone, give me a second. I'm going to share my screen. So what I'm going to talk about now is a little bit of a pivot from the specific IP and privacy considerations that Chris and Lori presented. And these are considerations specifically for not-for-profit organizations. I would say that these are in the categories of reminders of general rules and policies and procedures that not-for-profit organizations should be following in general in connection with all of your activities. But whenever there's a change in activities, and I think we're assuming that some of you are shifting to online content and are shifting from live activities in person to a new online focus. And this is a good time to sort of have a reminder about the different considerations that apply to not-for-profit corporations. So at the outset, a not-for-profit organization's board of directors is the body that oversees a not-for-profit organization and its activities. And in exercising that oversight function, each director is subject to fiduciary obligations. Those are the fiduciary duties of obedience, care, and loyalty. And we're going to talk about how each of those may apply in this context. So the duty of obedience is another way of thinking about it, is a duty of compliance. And this requires that directors ensure that a not-for-profit comply first with applicable law and regulations. So that includes the copyright and privacy considerations that Chris and Lori already spoke about, but also with a not-for-profit's internal governance documents, which are really its internal rules and regulations or laws and obligations, including making sure that the organization is faithful to the not-for-profit's mission and purposes as set forth in the certificate. So what does that mean in practice? A director needs to be familiar with the purposes of an organization as stated in the certificate of incorporation. This is the statement of legal purposes of the organization. And they need to have a general understanding of the not-for-profit's mission and purposes and its activities, and to make sure that those correspond with each other. To the extent, and this is important, there's a growth in activities. Certainly organizations evolve over time, and small organizations in particular may start with a very narrow focus and develop as support, funds, et cetera, all grow. And if there's a change in activities that results in sort of an expansion beyond the stated purposes in the certificate, then the directors need to ensure that there's an amendment to the certificate of incorporation. So what does that mean in this context? Before an organization engages in new activities, including new online activities, the directors need to ensure that those activities are consistent with the organization's mission and purposes. And if they're not, make amendments to the certificate of incorporation, which requires a filing with the Department of State and may require other approvals. So to use an example, a small organization is a writing workshop, and it's formed to instruct low-income students in creative writing. Can it move its instruction online? Can it start an online gallery for visual arts? Those are two very different questions. And I would suspect that a writing workshop's statement of purposes and its certificate of incorporation are broad enough to cover instruction in whatever medium is appropriate at the time. So likely a move to instruction online is not going to require a dramatic change in purposes, whereas starting a gallery for visual arts seems like a right turn into a whole different category of arts and a whole different category of activities. So this is something that the duty of obedience would require the directors to look into before creating a change. The duty of care is one that we've spent a lot of time thinking about, and this requires the directors act in good faith with the degree of diligence, care, and skill that an ordinarily prudent person in a like position would exercise under similar circumstances. So this means that you need to be an active participant in the organization. Directors need to attend board meetings, and they need to be prepared by reading materials. They need to be informed about what the organization is doing, be active and ask questions. So in this context, this requires an organization, a director of an organization that is directly impacted by pause in New York, for example, to understand the impact of that pause on the organization's activities. If you're an activity that, if you're an organization that exists to present material in schools as an after-school program, the shutdown of the schools is likely to impact your activities. So the directors need to understand and be aware of the impact of the situation on the organization, and just generally be familiar with the activities and finances. So in this context, this means that decisions about pivoting to online content need to be made within the context of information, information about activities, information about the organization's capabilities, and information about the organization's finances. So here's an example where a museum, it's a small museum, it has a small board and hasn't held a meeting in over a year. The directors have their first meeting, they do it online, and I'll put a pin in that for just a second, and they approve a very ambitious plan to pivot to online-only programming, and there's a significant expense to this because the organization needs to develop a full online infrastructure, they need competent staff to manage this program, and the directors approve this without looking into the budgetary considerations, and ultimately this leads to an alienation of the donors and the museum's eventual insolvency. This is a problem, and this is something where the directors could be subject to a claim that they didn't exercise their duty of care in approving that program. The duty of loyalty is the duty that probably directors are most familiar with, because in addition to being a fiduciary duty, there are statutory and other considerations that key off of the duty of loyalty related to conflicts of interest. So the duty of loyalty requires that directors act in the best interest of the not-for-profit organization and put the not-for-profit organization's interests above his or her personal interests. This requires maintaining confidentiality and also raising issues related to conflicts of interest. So in practice, a director needs to disclose his or her actual or potential conflicts of interest. In New York, not-for-profit organizations are required to have a conflict of interest policy, and those conflicts of interest policy are required to have certain provisions, which include an obligation on the directors to affirmatively raise conflicts of interest when they occur. And a director also needs to adhere to confidentiality policies. So in this context, I think one of the examples that Chris gave about a series of licenses you may need to acquire in order to put a dance that includes choreographic rights and music and actual dancing online is a good one. And in this case, a dance organization proposes to feature a performance online, and that requires licenses that would be that would include payments to insiders of the organization. So those payments need to be reviewed in the context of the not-for-profit organization's conflict of interest policy and approved in accordance with that policy. So as I've already previewed, the conflict of interest considerations key off of the duty of loyalty, but these are statutory and also internal governance. And there are federal and state statutes that inform conflict of interest policies. And as I said, in New York, organizations are required to adopt policies with certain provisions. The rules for Delaware organizations, and some of you may be formed in Delaware because that is a jurisdiction where many small organizations are formed, are slightly different and less onerous. I'm assuming most actually are New York organizations, so we'll skip ahead to those more detailed requirements. But following the Not-for-Profit Revitalization Act of 2014, there was a pretty significant overhaul in the conflicts of interest requirements applicable to New York not-for-profit organizations. And that included new procedures related to related party transactions. Related party transactions are transactions, agreements, or other arrangements in which a related party, which includes a director, officer, or key person, has a financial interest and in which the not-for-profit is a participant. And the law specifies procedures that an organization must carry out before entering into a related party transaction. And in the case of a related party transaction where the related party has a substantial financial interest, which unfortunately is not defined in the law, those procedures do require considering alternative transactions. There are also recusal provisions, so the related party can't participate in the approval. And all of this needs to be done in accordance with the conflicts policy. So as an example, an arts camp typically holds a summer arts program for children, and as a result of the pandemic, this programming has been canceled. I think this is something that is happening everywhere. But the camp does wish to make some programming available online. Because this is a small camp that's usually happens in person outside in a small camp facility, they don't have the digital production materials that would be required to actually put the programming online in a way that they want to. And there's a director that wholly owns a comprehensive production company that has offered to produce and host this content at a very substantial discount. So that is a related party transaction. The wholly owned corporation of a related party is itself a related party. And so this type of transaction would need to be considered under the related party transaction rules. And in the case where it is a substantial discount, even if it is a substantial financial interest of the production company, it's likely that a comparison of alternative transactions would lead to this being kind of reasonable and appropriate for the not-for-profit organization. So beyond fiduciary duties and conflicts considerations, a few other reminders. Not-for-profit organizations in New York that solicit charitable contributions, this is true not only in New York, but in many other states, most other states. Solicitation of these contributions requires registration. In New York, that requires registration with the New York State Attorney General's Charities Bureau. And it's often with the Attorney General's office in other states. But as a reminder, if your pivot to online content is establishing your first website and you want to have a donate button, you need to be registered to solicit as a primary matter, and you should make sure that you are registered to solicit, particularly if you're already soliciting. And there are disclosure requirements for solicitations, and some of those need to be posted on your website. The link here includes information from the Charities Bureau website on the disclosure requirements for solicitation. So that is something to keep in mind. Those solicitation, the language of the solicitation disclosure changed recently, so it's a good thing to double check anyway. The other thing to keep in mind is if you are soliciting for a specific charitable purpose, those contributions need to be used for that specific charitable purpose, absent approval to use them for some other purpose. So in the case where a museum has raised a substantial amount of funds pre-pandemic to build a new facility and has determined that actually that's not a great idea under the circumstances, and proposes to use the funds to buy, you know, an extensive library of IP rights to put those online, that's something that the capital funds raised for the new facility can't be used for unless the museum has preserved that flexibility or otherwise obtains approval to use these funds for an alternative purpose. That's another important thing to keep in mind. I suspect most of the small organizations represented here are not endowed, or if you do have endowments, they are for specific narrow purposes. But in this context of market dislocation and you know, increased need on charitable organizations, including arts organizations, there has been some attention to endowment spending, and it is important to keep in mind that decisions with respect to endowments, including a decision whether to appropriate for expenditure or to accumulate, need to be made in good faith and subject to the same prudence standards similar to what we talked about in the duty of care. So that's another just important thing to keep in mind if you are an endowed institution. And then the last reminder is just a reminder about unrelated business income tax. So as a not-for-profit organization, you're recognized as exempt, or you may be recognized as exempt from federal income tax under Code Section 501c3. But that exemption doesn't apply to income earned from conducting an unrelated trade or business that's regularly carried on. So your pivot to online content can't be, or I mean, if it is a pivot to an unrelated business, that has implications for your federal tax exemption generally, but also if you are undertaking an unrelated business, such as an online store on your music school website, that is something that, where the income may be subject to tax. So that's another thing to keep in mind. Unrelated business income tax is complicated, particularly for smaller organizations that are not otherwise investing entities and may not be filing the specific IRS forms that you are required to file once you have UBIT. So that is just another reminder. And that is all I have on the not-for-profit reminder side.
Okay, great, thank you. So Mara, we have a couple of questions. I know that, Maura, we have a couple of questions. I know that Mara has one for you, and she'll pop in just a second, I think. Hold on a second. I'm not seeing her yet.
Can you see me?
Yes.
Okay, great. Thank you, Maura. That was a great presentation. I'm just wondering about board training regarding the duties of a board member. So do you suggest that take place often, annually, only for new board members? How do you guide organizations on this?
I think that's an important question, and it like everything else is going to depend on the organization, how often there's turnover in the board, the types of the functions of the board and their involvement with the organization. It is absolutely something that we recommend is done as part of the onboarding process for new directors, but it's certainly something that should be an item, a refresher item for boards periodically, whether that's at the periodic retreat that the board might have, or at other regular intervals. Those types of reminders about duties and your general oversight obligations are helpful reminders to have. I will say though that in addition to that's sort of a statement on the more general, these are fiduciary duties and these are your obligations. With respect to the duty of loyalty and the conflicts policy in particular, the conflict of interest policy that is adopted in accordance with New York law does require annual disclosures. So to the extent you're touching on the duty of loyalty in your conflicts policy, that's something that will be refreshed and should be refreshed on an annual basis. And I will say one final comment, which is just, and I meant to make this plug earlier, but the Attorney General's Charities Bureau website has a library of guides and publications that are extensive, very helpful, cover lots of different subject matters. And there are guides there for directors of nonprofit organizations. There are specialized guides that have been published recently in light of COVID-19. So that's a great resource for directors who want to refresh themselves even outside the normal cadence of board level refreshers.
That's great. And a related question, which is who should deliver the training?
I think that's going to depend again on the type of organization. I think where you have outside counsel that provides advice in this area, it's great for that to come from outside counsel or inside counsel, but counsel periodically. In other cases, particularly for smaller organizations, often there is a lawyer on the board. Often that person serves as the corporate secretary, and sometimes that person may take on the role, but it is. It's helpful, I think, to have an outside advisor provide that information where possible, or for it to at least reference outside materials, which is why I did want to reference the AG's materials, since those are free and available to the public.
Great, thank you.
So I actually want to just put in for the attorneys who are getting CLE, the third code is capital C, small d, capital R, small s, capital N, 6. And then a question is, if a nonprofit is a producing organization of live theater, would a temporary pivot to online only content under these circumstances we have now constitute a big enough change to warrant an amendment to their mission?
I think, so there's and I should be more precise about this. There's a difference between, in some organizations at least, there's a difference between what you consider your mission to be, which I like to think of as sort of a personal brand almost, versus your statement of purposes and your certificate of incorporation. So if your certificate of incorporation purposes are broad enough to cover not only live theater productions, but also taped versions of live theater productions produced online, which I would expect they would be, then that's fine. And I think the mission statement, like I said, is more of a statement of the board of what your priorities are, what your vision is. That needs to correspond to your statement of purposes from the certificate of incorporation, but I wouldn't say that you need to add and colon also or dash also online in COVID-19. That's the sort of thing that I think it's a level of detail that's really not required.
I agree. Okay, so here are a couple of questions that are related to donations. So if one person's asking, is registering to solicit donations the same as being registered as a business in the state as a nonprofit?
It is not. You are registered, well, it is not the same as being registered with the Department of State. So for example, you may be a Delaware corporation that has applied and received authority to conduct business in New York, and that's a filing that's submitted to the Department of State. The registration with the Attorney General's Charities Bureau it has recently been moved to an online form. I think we still call it the CHAR 410, but I'm not sure. Okay. But you register with the Charities Bureau, and you register either as an organization under Article 7A of the executive law, which is a registration to solicit contributions, or you register under the Estates Powers Trust Law.
Trust law, yeah.
Did I do that? As an organization conducting activities or holding assets in New York. So it isn't the same, especially if you've only registered as an EPTL filer and now you're going to start soliciting. You do need to amend your registration. So for two reasons, it sounds like no, that is not sufficient to register to solicit. So you want to check, and just another plug for the Charities Bureau website, you can check your own registration there. You look up you put in your EIN or your name, and it will tell you if you are either a dual registrant or, for example, an EPTL registrant. And if you're an EPTL registrant, then you're not registered to solicit.
Okay. So again, when soliciting online, if donors are not located in the state in which you're organization is registered to solicit. So you're, because we all have our websites with donate now on it, and we're getting donations from everywhere. So if your donors are not from this state, does the organization have to go to the other state to register?
So generally, no. If we're talking about a website registration, no. If you are specifically targeting, and this is sort of a difficult area of the law, but the rule of thumb is if you have a website and you are not specifically targeting people in California, but people who live in California can use the internet and visit your website, that doesn't mean that you need to be registered in California. If you're a New York organization, let's say you're a small theater organization upstate, you may have a cousin who lives in California who wants to donate to your organization, but that doesn't mean that you need to register there. California is not a great example because I think California would like everyone to be registered in California. But
Amy, I'm seeing.
By contrast, if you are a more national organization that has a presence in New York and you're going to hold a fundraiser in Illinois, then there are different rules that apply. So it depends on the type of solicitation that you're conducting. And if you are holding an in-person fundraiser in a state where you are specifically targeting individuals in that state, then you should probably expect that you'll need to register. That could just be a temporary registration for the year in which your event takes place.
Amy, I'm seeing a question about conflict of interest.
Sure.
Can I go there?
Yeah.
So this is if the board member is offering, if a board member is offering services for a discount on market rates, can they receive compensation? For example, the board member's video company videotaped for half their fee, which is lower than market rate.
So you can enter into transactions with insiders subject to adhering to both your conflict of interest policy, and your conflict of interest policy should reflect the related party transaction rules. But in the event it hasn't been updated since 2014, this is a good reminder that you should go ahead and take a look at that. And that's another resource that is available on the Charities Bureau website for you. But that is the type of transaction that could be approved, but it needs to be approved in accordance with the applicable conflicts policies. So it sounds like that would likely be a related party transaction because there's a financial interest of a director, presumably. We don't know any. The facts stated don't indicate whether the director owns the company, but we'll assume that he or she does. So that would be a related party transaction, and subject to adhering to the approval requirements, it's something that the corporation could enter into. One of the things that I will say on those types of transactions is it is very important to maintain a record. And so small organizations that may not be in the habit of maintaining comprehensive meeting minutes should be especially comprehensive in approvals of those types of transactions, so that there's a record that says we know that this was this type of transaction and we approved it anyway, we thought about it and it was half price and we decided this was the best way to go, even though there is a benefit to our insider.
Great. So document. Thank you.
Yes, always document.
Always document.
So we have a couple of questions about unrelated business income, and I'm going to try to sort of pull them together. The first one, our merchandise sales are under $500 a year. We sell swag with the company logo. Do we have to file taxes? So that's actually kind of a two-pronged question, but I'll let you answer.
Right. So there are exceptions to merchandise that shows your logo, and other there are other exceptions apply to, for example, something that you do just once, it's not regularly carried on. So no, not necessarily, but that's something that you need to discuss with your tax preparer. But as a general rule, no. And the point that I was making was more, if you have an opportunity to sell something that's completely unrelated to what you're doing, which seems like maybe a great idea because you're looking for revenue to replace revenue streams, just keep in mind whether or not that's related or unrelated, because there could be a tax there that you're not accustomed to paying.
And I think the cutoff is $1,000. You have to earn over $1,000 in order to be subject to taxes on those things.
That's correct.
So
there's a $1,000 freebie.
Freebie, yeah, exactly. So a nonprofit performing arts center wants to know if they monetize streamed performances, is that still related income? I would think that yes, I would think so.
depending on the facts, yes, that sounds like it would still be related income in the same way that, for example, charging tuition, if you're a school and you charge tuition, that's in furtherance of your educational purposes, and that's related income. So it may be a pivot for what you're doing, but that would still be related in the same way that other sales of art related things are for that type of an organization.
And I think the answer is the same for if a music school sells videos of their kids' performances to the parents, is that related income?
That's related.
I would think so too.
Yeah.
Mara, do you see any other questions? That I think we're pretty much out of time. We're just at time now. And actually, I know you had some closing statements you wanted to make. So
sure. I also wanted to say thank you to everyone, to Amy, to Volunteer Laureates for the Arts, to Lori, Chris, and Maura for being with us today. This has been an incredibly rich conversation. We received 114 questions. And Amy and I, as well as Abigail Young, who's our general counsel, have been back-channeling through this seminar to say what more can NYSCA be doing, because it seems like there's certainly more to address. And so with that, we're thinking about an online Q&A that maybe addresses some of the key topics that were raised today. So stay tuned for that. In the meantime, a lot has been said or mentioned about the Charities Bureau, and I'm happy to share that you can join us here at the NYSCA Presents next week, June 10th at 11 a.m. We're going to be joined by Jim Sheehan, who's the chair of the Charities Bureau at the Attorney General's Office, and he's going to be talking on topics such as critical nonprofit legal governance, use of charitable assets, and funding matters in the time of COVID, and other issues, I think, including mergers. Two quick reminders on some funding opportunities at NYSCA. One is we're still offering an artist grant in partnership with New York Foundation for the Arts. That application opens on June 9th. Please visit our website or NYFA's website. We have just learned that the MAF opportunity, which was posted yesterday, had overwhelming interest, and they have just taken down that and closed that portal. I also want to just share that in closing, we're all aware of the immense challenges that we're facing today and in the future. We're with you on this path, and we're here as a resource. We hope today has been a rich experience for you. We know that our community, and this is a great example of it, is resourceful, resilient, and above all, creative. Thank you for being with us today. Thank you to BLA, and stay safe and be well.
And thank you all.
Thank you, guys.
Thank you so much for your time and helping put this together, everyone.
Thank you.